from your intellect or your creativity. The characteristics of intellectual property are that it's territorial, it's limited to a duration of time, and only eligible subject matter is protected. So a lot of the times I get people coming to me asking, please protect my idea, but it's not all ideas that can be protected under intellectual property, only certain ones that actually meet the criteria for protection. Intellectual property encompasses many different types. So we have patents, we have trademarks, copyright, trade secret, traditional knowledge, geographical indication, utility models, and trade secrets. All this type of intellectual property is used to protect different types of ideas. So for example, I can hone in on patents. Patents are a type of intellectual property that we use to protect scientific or technological inventions or innovations that meet three criteria: novelty, industrial applicability, or or inventive step. So we don't patent songs, we copyright them. So patents are reserved for scientific or technological inventions and innovations. So just to understand that different types of intellectual property are for different types of ideas. So coming into copyright, copyright protects the intellectual creators in the literary, musical, artistic, and scientific fields. So copyright is reserved for written works in the literary field, the musical field, the artistic, and scientific. So in this case, we do not protect the idea of a poem, we protect the written expression of a poem. We do not protect the sound of a song, we protect the recording, the voice recording and the musical recording of a song. In terms of artistic works, we protect sculptures, paintings, and in the scientific fields, in some jurisdictions, we protect the written code of a computer program. So the two rights that are granted to a copyright holder are moral right and economic right. Sometimes a copyright holder has both rights, at other times they don't, they only have one right. I'll explain the rights first and then explain to you why it is not automatic that each holder gets both rights. A moral right is the right to paternity, meaning it is a right to be named as the author of the work or the creator of the work. So the moral right merely gives you the right to be named as the author of the work. The economic right gives you the right to make money off the redistribution of your work. Meaning, when different copies of your work have been produced and sold, you get the right to benefit off that work. The reason why copyright does not automatically mean you are granted with both the moral and economic right is in cases of employment. All of us are employed by an institution. By virtue of signing our employment contract, what we tell our employer is that any work that we make in the course of our employment will belong to the institution. So anytime I write a book, my rights to that book will be less than if I were unemployed or if I were employed by myself. So in an academic arena, as employees and students of institutions, we only have the moral right to our work, meaning the right to be named as the authors. However, the institution retains the economic right to make money off the copyright. What a lot of institutions have is IP sharing agreements. What this means is that in the event that you create a work that should be protected by copyright or any other intellectual property, you sign an agreement with the institution that will allow a ratio split of the profits made off that IP. Some institutions say 60-40, meaning the creator, the student or the staff member gets to benefit 60% and the institution 40%. because they recognize that they would not have had the ability to make that money had you not created the work. In other institutions, they flip the ratio around, that the institution gets 60% and you as the creator get 40%. I'll pause here to explain a very common case that we might know of or might not know of. The case of Google was a PhD proposal. It was a PhD proposal by 2 students at Stanford University. When they completed their PhD, they decided to roll it out as a business. However, because they studied at Stanford, it belonged to the university. Stanford entered into an agreement with the 2 students for a partnership pairing, where the institution got a percentage of the royalties made from Google. And then after the 3rd year of operation, when Google succeeded, Stanford gave the 2 students the opportunity to buy out the university, which they did. So those are different types of models we see of sharing. Copyright is the longest lasting intellectual property. It lasts for the duration of the lifetime of the holder, plus 50 years after they die. So Michael Jackson, Whitney Houston are all still making money off their music even though they're dead. The requirements for copyright are 2. Originality, meaning it must be an original piece of work, which I will explain in a moment. The subject matter must be tangible, meaning you can't come to me and ask me to protect an idea that is in your head. It has to be expressed in a tangible manner. Either you've written it down on a book or you've recorded it on a CD. The applicant must be a registered persona. And because my presentation is a little short, I will actually explain the 2 things with interesting stories. I find intellectual property is easier explained with stories. So originality. We have a case where Barack Obama's presidential campaign photo, the Hope photo, was taken by one photographer called Manny Garcia. Manny Garcia took a normal photograph, and then Shepard Fairey took that photograph and altered it with stencil to give us the red, blue, and beige that we see in the poster. Now, the fight became that Shepard Fairey, having changed Manny Garcia's original photo, is the one who gave the photo publicity and gave the photo the ability to be sold commercially. However, the argument was he wouldn't have had that photo had Manny Garcia not taken the photo. So then the courts decided to rule in both their favor because ultimately the new photo that Shepard Fairey created with the red, blue, and beige was an original piece of work. So that's how we look at originality. IP professionals have a saying, we believe that there's nothing new under the sun. So what we look at is your ability to tweak what is already present into something new. The last point, applicant must be a registered persona. An interesting story happened when a photographer from Britain went to Asia and left his photo, his camera on a tripod in the middle of a zoo. He went to go to get something from his car. When he came back, he found the monkeys playing with his camera. The one monkey took a selfie, and it became such a well-known selfie. The zoo sued this photographer for copyright infringement because they said that the copyright belonged to the monkey. In the US, when they got to the US courts ruled in the favor of the photographer and said that unfortunately, copyright protection is offered to registered personas. The monkey is not a registered person. However, the zoo was still not happy with this ruling, and they went to PETA, the Organization for Animal Rights, and they sued the photographer in the UK. And their argument was that that photographer made a lot of money from that photograph. And they were saying that if they could share in the profits of the photograph, it would help them to keep the zoo habitable for the animals. So because this poor photographer started losing a lot of money in legal fees, they eventually settled out of court. So you see, there are very silly examples that happen, but I find it drives the point home. So at this present time, copyright has the most non-exhaustive list of eligible matter. So the poet, the software coder, the architect, the sculptor, the songwriter, the actress, the producer, the broadcaster, all are protected under copyright. The economic benefit of copyright is that the registration of copyright is handled by the state because it is a legal matter. So registration fees are then collected by the respective government, so it could contribute to the fees in the government. Copyright use is subject to taxation. So the more copyright protection we have and the sales of it, you actually get taxed. It creates employment directly or indirectly related to copyright. It contributes to GDP, and it contributes to trade in terms of export and import. I'll explain all of these in a moment. Although we cannot compare the US with Namibia, I find that the US is a very good example of good use of copyright. You'll see that in the year 2015, $2.1 billion was contributed to the US economy from copyright. We see the core industries, the singers, songwriters, poets, painters, writers, contributed up to 1.2 million. And then there were other independent and non-dedicated areas of IP that were contributed to copyright. So now these are the actresses, the producers, the broadcasters, etc. So just in fact, you see copyright contributes to up to $1 trillion in 2015. It employed almost 5.4 million people in 2012, in the US. And foreign sales in terms of selling and exports were up to 142 billion US dollars. Nigeria and copyright. Nigeria, in essence, became the top economy in 2013 because they included Nollywood into the economy. Namibia and copyright. Right now, we have a very healthy legislative framework. We have all the legal framework that we need for copyright and intellectual property protection. We have relevant organizations for copyright, which is BIPA, and then MASCHEM, and then NAMRO. And these are all the organizations responsible for royalty payments to artists. You'll see we have a long way to go. In 2016 to 2017, we had 204 applications of copyright. 190 were accepted, and copyright in Namibia at present costs $100. So you can just say 190 times 100 to see how much money we made from that, which was not much. In terms of magazines and newspapers and periodicals, we had 13 applications, all of which were accepted. Again, costs 100, so we made 1,300. So we need to improve that. The recommendations to this would be that we need more awareness campaigns on copyright. We need more enforcement in terms of NASCHEM and NAMRO. And we need increased awareness in the media, especially about copying and social media. And then also better management from the legal fraternity. We need the lawyers to stand with us in enforcing people's rights. Thank you very much.